Welcome to What's the Scenario with PLRB, where we explore claims and coverage scenarios relevant to insurance professionals. I'm Alicia Watley.
I'm Mike Broad.
I'm Tim Havler.
And I'm Brennan McLaughlin.
Hey Brennan, what's the scenario?
Isn't it Tim's turn to do a scenario?
Wait a minute, I thought it was Mike's turn.
Oh, hold on here now. Alicia, don't you have anything to talk about?
I never come with a scenario. I don't know what you're talking about. But, we've done so many of these. Let's just play another one.
A replay, a best of. That will be very exciting.
Today we're going to feature an excellent podcast from before we rebranded as What's the Scenario with PLRB. These segments were called the Coverage Contrarian, and they featured PLRB coverage attorneys Michele Hunter, Eric Friedmann, and Frank Gagliardi as they argued vociferously about coverage issues big and small. This week we'll explore the expected or intended injury exclusion when a person punches another in the jaw without knowing their own strength. Let's listen in.
Okay, without further ado, let's jump right in, beginning with the language of the exclusion itself. Frankie.
Of course. So in the standard homeowners policy, such as the HO 00030511 form, the exclusion reads as follows. Coverages E and F, which are the main liability and med-pay coverages, do not apply to the following: expected or intended injury, which is bodily injury or property damage, which is expected or intended by an insured, even if the resulting bodily injury or property damage, A, is of a different kind, quality, or degree than initially expected or intended, or B, is sustained by a different person, entity, or property than initially expected or intended. Now, this has been the language used since the 2001 edition, and it differs significantly from the previous version of the exclusion that is found in the older 91 policy, which merely stated that the policy did not apply to bodily injury or property damage that was, quote, expected or intended, end quote, by the insured. Obviously, the newer policy language is much broader in terms of what is meant to be excluded by or subject to this exclusion.
Great. Thank you, Frankie. So in this segment, we're going to discuss the application of the expected or intended injury exclusion in 4 different factual scenarios. First, in an assault case. Second, in a shooting case, or should I say scorned mate case, which is just a little teaser of what's to come. Number 3 or third, in a horseplay or like a practical joke type of case. And then finally, we're going to discuss this exclusion in a case involving just plain stupidity on the part of the insured. Of course, a technical term.
All right, I'm with you so far.
Okay, beginning with scenario 1 and assault. In this scenario, let's assume that the insured punches another individual in the face and the punch ultimately breaks the person's jaw. Let's further assume that the insured claims that while he intended to punch the person in the face, he did not intend to break the person's jaw. What do you think, Frankie? Does the expected or intended injury exclusion apply here?
Well, yes, I think it would. Under what you've presented here involving a punch and a broken jaw clearly warrants the application of the expected or intended injury exclusion. And there are 2 cases that are directly on point. The first is a Pennsylvania case from 1989, State Farm Fire and Casualty versus Levin, where the court expressly ruled that the expected or intended injury exclusion barred coverage for the insured who had punched the claimant in the face that crushed his cheekbone. The court rejected the insured's argument that he, quote, did not know a single blow could break bones, end quote. The insured found, and I'm quoting here, intended to cause serious physical damage to the claimant's face, end quote. The fact that the claimant's injury may have been more serious than what the insured intended did not affect the application of the exclusion. And then there's a case out of California from 1991, Fire Insurance Exchange versus Alteri, where the insured who had intentionally struck the claimant in the face was not entitled to coverage There, the court stated that where the insured acted intentionally in striking the claimant, the fact that the claimant sustained greater injury than the insured intended did not affect the application of the exclusion. Therefore, it applied to deny coverage. So, pretty open and shut here, Michele. Facts such as these will almost certainly trigger the application of the exclusion.
Frankie, that would be the majority approach, is what you're saying.
Actually, I think that would pretty much be the only approach where the insured intentionally strikes another person.
Well, I understand your position, Frankie, but I do have to make you aware of a Louisiana Supreme Court case that actually reached the opposite result under the very same fact. This case that I'm talking about, Breland versus Schilling, which is, again, Louisiana Supreme Court in 1989, that case involved an insured who punched a claimant and broke his jaw. And just like the above cases, the insured argued that the punch caused substantially greater injury than he had anticipated. But unlike those other cases, in the Breland case, the Louisiana Supreme Court was actually persuaded by the insured's argument. And they said that the exclusion did not apply to bar coverage. And the court actually rejected the approach that an insured intends, as a matter of law, all injuries which flow from an intentional act. So basically, the Louisiana Supreme Court found that the claimant's serious bodily injury was not intended or expected from the standpoint of the insured.
But how can that be? In any situation involving a punch to the face, the insured intends to cause some sort of bodily injury, whether it's a broken jaw or a broken nose or a black eye or whatever the case may be. A punch in the face is not the type of gray area where it's unclear whether the expected or intended injury exclusion should apply. Bottom line, it should apply.
Well, okay. Well, whether you agree with it or not, Frankie, here's what the Louisiana Supreme Court said. They said that where there's minor bodily injury intended and then minor bodily injury results, the injury is precluded from coverage. And of course, the same reasoning applies where a serious injury is intended and then a serious injury results. But if a minor injury is intended and then for whatever reason, a serious one results, coverage for the serious injury is not barred.
That is a fundamental misinterpretation of the expected or intended injury exclusion.
Which brings me back to my original point of why it's so important to know what jurisdiction you're dealing with it when it comes to this particular exclusion. Because again, we have the same facts in an assault, and the Louisiana Supreme Court here reached the totally opposite result regarding the application of the exclusion.
I guess, but I would point out that this Breland decision is from 1989, which means that the Louisiana Supreme Court was interpreting the older version of the exclusion, which, as I pointed out in the beginning, simply excluded coverage for bodily injury or property damage, which is either expected or intended from the standpoint of the insured. And to be fair to the minority position, the law does require the court to adopt an interpretation of an exclusion that provides the insured with the greatest amount of coverage, and an expected or intended injury exclusion with the subjective intent requirement would provide the insured with a greater amount of coverage than an exclusion without such a requirement, which is why I think this ruling and the others like it were the reasoning for the broadening of the exclusion in the newer homeowner policy form by the addition of the language that I quoted earlier, that the exclusion applies even if the resulting bodily injury or property damage is, quote, of a different kind, quality, or degree than initially expected or intended, end quote. So with this broader language being in use more and more going forward, I think Breland is pretty much limited to the older version of the exclusion.
You raise a good point, Frankie. What you're saying is that whenever a claims adjuster is faced with the application of the expected or intended injury exclusion, it's important to know not only the jurisdiction, but also which version of the exclusion you're dealing with.
Yes, that's always true.
Okay, then time to move on to our second scenario entitled Estranged Husband, because I could never come up with facts more interesting than what happened in the case of Barton versus Allstate Insurance Company. It's another Louisiana case, but this time an appellate one from 1988. So in Barton, a husband and wife had an on-again, off-again relationship for 5 years. The husband, James, ended up moving out of their trailer, and the wife, Kayla, remained. And then Kayla started dating a man named Wayne. So one night, Wayne stayed overnight at the trailer with Kayla, but James showed up around 4 a.m. demanding to be let in. Kayla told Wayne to go hide in the bathroom, and then James broke into the trailer, walked into the bedroom, and asked where the tall, lanky son of a blip was. Kayla responded that no one else was there, but James noticed that the bathroom door was closed. So after kicking the door once, James whips out his .357 Magnum revolver and shoots into the door, causing Wayne to scream, "I've been shot." So what do you think, Frankie? Should the expected or intended injury exclusion apply here?
Of course, John, the husband, intentionally shot into an occupied bathroom in a trailer, no less.
Exactly right, Frankie. The Barton court said that although Wayne was in the bathroom behind a closed door, James knew that someone was in the bathroom and then intentionally fired the gun at the door. So yes, the intentional act exclusion applied in that case.
Under those facts, I think that's the only result the court could reach. Not that I don't feel bad for poor Wayne.
You'll be happy to know that Wayne was shot in the leg, and so he lived.
Well, that's a relief.
Okay, but what if we tweak the facts a bit and talk about a shooting scenario that's a little different?
Okay, we both know how much I enjoy tweaking the facts a bit.
So what about a situation involving an insured store owner who's been burglarized 3 different times? Based on these burglaries, let's assume that the son of the store owner decides to spend the night at the store in order to guard it, and he brings a shotgun with him. So that evening, as predicted, someone attempts to enter the store through the door with a pry bar, and the son fires a shot at the entry door. And the shot that the son fires hits the lower left side of the door, and it ends up injuring this 11-year-old would-be burglar. So what's your opinion here, Frankie? Does the expected or intended injury exclusion bar coverage in this case?
Oh, yes, the answer is clearly yes. The exclusion should apply to deny coverage.
And why is that?
Well, because the son fired the gun at the door while the burglar was attempting to pry it open. Just like in the Barton case with poor Wayne on the other side of the bathroom door, the son shot at the entry door knowing someone was on the other side. Under these facts, the expected or intended injury exclusion should definitely apply because the injury to the would-be burglar was intended or at least expected when the son shot at the door knowing there was a person on the other side.
And your point is exactly what the insurer argued in that case, the name of which is Auto Owners Mutual Insurance Company versus Stroud, which is an Indiana appellate case from '91.
Well, that's what I'm saying. Whether it's stolen love as in the Barton case or stolen merchandise as in the Stroud case, the result is the same.
Actually, that's not what the Stroud court found.
Wait, that can't be right.
So the Stroud court was actually persuaded by the argument that the son did not intend or expect the injury. And that court stated, again, the Stroud court, that it was possible that the son was only attempting to scare the intruder away. And that's the whole reason he shot low on the door, so he would avoid injuring anyone.
In my mind, there's no meaningful difference between Barton and Stroud. Both shooters intentionally shot through the door knowing that a person was on the other side. And you know what, Michelle? Shooting a gun knowing that you might hit someone should be enough evidence of wanting to cause that someone injury to trigger an exclusion for expected or intended injuries.
As I said at the beginning, this is another example of the same facts, but different results depending on the particular jurisdiction.
Bad law, in my humble opinion.
Well, anyway, let's move on to scenario number 3, which involves a factual pattern of general pranks. So in State Auto Mutual Insurance Company versus Scroggins, and this is a Florida appellate case from 1988, the court found that the expected or intended injury exclusion applied to deny coverage for injuries that were caused when an insured intentionally pulled a chair out from underneath the claimant. So the court said the exclusion applied, even though the insured had no intention of causing the claimant any serious injury.
Well, that sounds right to me. In another case involving horseplay, Pachuki versus Republic Insurance Company out of Wisconsin in 1979, involved coworkers who were horsing around with a game called greening pins, which was essentially the shooting of paper clips with rubber bands. And during this greening pin war, one of the coworkers was struck in the eye and injured. And there, in that case, the Wisconsin Supreme Court ruled that the expected or intended injury exclusion applied because it does not require proof that the insured specifically intended to cause the resulting injury, but only that he intended the act to cause some kind of bodily injury. In other words, even though the insured fired paper clips intending to hit the claimant's body without causing him any serious injury, he knew that some harm could be caused by being struck by a paper clip that was traveling at high speed. And that's all that was needed to make the exclusion apply.
Okay, so that's a Wisconsin case, right?
Mm-hmm.
Okay, so how do you think that case involving greening pins squares with the ruling in another Wisconsin appellate court's decision? This one's from 1995 called Prosser versus Luck, in which a group of juveniles engaging in some pranks at a warehouse, basically one of the juveniles, they broke into the warehouse, and then one of the juveniles ignited gasoline drops on fire on a concrete windowsill. And right after it caught on fire, he then kicked the bottle containing the gasoline down a hole in the floor. So although the juvenile engaged in an intentional act of playing with fire and even admitted to, causing some minor harm from starting the fire, the court stated that severe damage to the building was not substantially certain to follow. According to the court, because a fire destroyed the entire building, was so far removed from burning small amounts of gasoline on a concrete windowsill, the destruction of the building was not expected or intended by the juvenile. So the Prosser court ruled that that exclusion in the parents' homeowners policy did not apply in bar coverage.
I would admit that it sounds like a hard circle to square, but it should be noted that a jury had found that the juvenile's action of starting the fire as being negligent rather than intentional conduct. So this meant that the court had before it an insured who, while committing the intentional act of playing with fire, still had no intention of causing damage to the property that was ultimately damaged by the fire. So unlike the insured in Patuchki, who intended to cause some bodily injury to the claimant by striking him with a paperclip, the juvenile in Prosser had no intention whatsoever of causing the damage to the property by his playing with fire. I guess that was enough of a factual difference for the court to conclude that Patuchki didn't apply.
Okay, in this situation, we've got the same jurisdiction of Wisconsin, but different outcomes regarding the application of the exclusion. So that must just be because of the particular facts involved.
I'd say the different outcome in these Wisconsin cases are at least arguably justifiable, or maybe nothing more than results-oriented jurisprudence, but we'll never know now.
That sounds like the perfect segue for our fourth and final scenario involving stupidity, for lack of a better word, on the part of the insured. For this last scenario, let's assume now that the insured enters a clothing store, finds a shirt to try on, and then approaches the dressing rooms. But as he does that, he's made aware by another female patron in one of the dressing rooms not to come into, her particular dressing room. But the insured starts rummaging, feeling, and grabbing the other female patron's curtain in an attempt to make physical contact with her. After that, the insured kneels down and uses his phone to take videos or photos of the female patron under her dressing room curtain. Based on these facts, Frankie, does the expected or intended injury exclusion apply to bar coverage?
Well, that's a definite yes, in my opinion, Michelle.
Well, why are you so sure?
Because the insured clearly intended to make physical contact with the female patron through the dressing room curtain. And even if that behavior could somehow be excused or justified, which I doubt, the insured then did it a second time with his phone in an effort to take either photos or pictures of this woman.
Would it matter to you if I added some additional facts, such as the patron's reaction to the insured's behavior, where she tried to laugh it off and make a joke out of it by saying, "Ha ha, you don't want to spoil your breakfast"?
All joking aside, while I agree that these cases are very fact specific, the patron's reaction does not change my conclusion that the exclusion should apply. Not once, but twice, the insured tried to access the female patron's dressing room, either by rummaging through the curtains or by going underneath the curtains with his phone to take a picture or a video.
Then it would surprise you if I told you that last year in 2020, the Hawaii Federal District Court held that under this very fact pattern, the intentional or expected injury exclusion did not apply. And the name of the case, by the way, is AIG Property Casual Company versus Annenberg.
But what about the insured's conduct of putting his phone under the other patron's dressing room curtain? How does the court ignore that fact?
The Hawaii court did actually address that very fact by saying that the phone video did not rule out the possibility that the insured did not expect to cause harm to the patron. In other words, the evidence could support the insured's theory that because the patron sounded like she was joking when she said, "You don't want to spoil your breakfast, haha," the insured did not intend or expect to harm her at the time he did that. So according to the court, even if the patron's comments were meant to, diffuse an inexcusable situation, it was possible that the insured could have interpreted them such that he did not expect to harm her.
Well, that, in my humble opinion, is jurisprudence with no defense. How could one willingly violate a female patron's space through a dressing room curtain more than once be anything other than intentional conduct?
I mean, apparently the Hawaii court placed great emphasis on the female patron's response to the insured's conduct by joking.
Well, if you say that case is out there, I'll take your word for it. However, that doesn't mean the Hawaii court reached the proper result or even applied the proper analysis regarding the expected or intended injury exclusion. In my opinion, the majority of jurisdictions in this country would reach the opposite result based on those facts, but it is what it is.
So, once again, to beat a dead horse, this is why it's so important to know your jurisdiction when it comes to the expected or intended injury exclusion. Well, there you have it. Another lively discussion with the Coverage Contrarian on the subject of the expected or intended injury exclusion. To recap, let's summarize.
Michele, if I may, please allow me to summarize the few principles we do agree on. And those are, in summary, when considering whether this exclusion applies to a given claim, one must always know the jurisdiction whose law would govern, because it may be wrong, the version of the exclusion contained in the policy you're dealing with, and most importantly, one must know all of the relevant facts bearing on the application of the exclusion.
So, Brennan, what can we take away from this scenario?
When considering whether this exclusion applies to a given claim, one must always know three things: the jurisdiction whose law would govern, the version of the exclusion contained in the policy you're dealing with, and most importantly, one must know all the relevant facts bearing on the application of the exclusion.
Mike, where can an adjuster go to learn more?
That's a fantastic question, Tim. I think folks could always go out to plrb.org, check under the education section. For a full back catalog of all of our podcasts, most of which include references to related articles, webinars, and other resources. Hey, Alicia, can we share those in the links in the show notes?
Yes. And there you'll be able to find a recap of the key points from this episode, links to our social media, and information on how to submit your own adjuster story. No, don't forget to subscribe and rate us, and we'll see you all next time.
See you next time.
Bye, everybody.
The views and opinions expressed in this resource are those of the individual speaker and not necessarily those of the Property and Liability Resource Bureau, its membership, or any organization with which the presenter is employed or affiliated. The information, ideas, and opinions are presented as information only and not as legal advice or offers of representation. Individual policy language and state laws vary. and listeners should rely on guidance from their companies and counsel as appropriate.